Dear delegates, audience, the first webinar session in the webinar series for contestants of the Vietnam CISG Pre-Moot 2025 competition will begin in just a few minutes. Please settle in your seats and verify a stable connection so that the webinar session can officially begin. Thank you very much. We would like to warmly welcome all candidates who were interested and registered in the competition Vietnam CISG Pre-Moot 2025. My name is Thảo Linh, the MC of today's webinar. First of all, Thảo Linh would like to send sincerely thanks to all the distinguished guests for being here with us today. Thảo Linh wish all of you luck, health, and happiness. Dear delegates and audience, this webinar is designed to provide candidates with valuable sharings from former CISG Pre-Moot contestants and also the fundamentals of Moot. Our aim is to offer valuable insights, targeted expertise, deliver focused knowledge, and the readiness needed to be excelled in the upcoming competition. Hopefully, this session helps you gain the clarity and confidence needed for your preparation. Coming to this webinar session, the organizing committee is honored to welcome the participation of the following speakers. First, LLM Trần Thanh Tâm, lecturer at Foreign Trade University, Ho Chi Minh campus. Mrs. Đỗ Minh Châu, Đỗ, champion of the Vietnam CISG Pre-Moot 2020. Mr. Phạm Xuân Phong, third runner-up, Vietnam CISG Pre-Moot 2023. And I would like to invite our three speakers to turn on the micro to talk and interact with the audience.
Okay, good evening, everyone. You hear me well?
Yes.
And I hope you're doing well. Yeah, so just send my best regard to every single audience in the very lovely evening tonight.
Yes, thank you.
And look forward to a very fruitful training and discussion around the table today.
Yes, thank you.
Hi everyone, I'm joining in from Canberra in Australia right now. It's quite late, but I'm really happy to be joining this webinar and sharing some of my experience with CISG Moot with all the people joining the webinar today. And hopefully we will have a very fruitful competition this year.
Yes, thank you.
So maybe I'm the last one, and good evening, ladies and gentlemen. And my name is Xuân Phong, and I'm very proud to be here today with two really distinguished guests, which is Mr. Trần Thanh Tâm and Miss Carla Đỗ. And I also look forward to an exciting exchange between Mr. Tâm and Miss Carla. And I wish you guys will enjoy this evening's session. And thank you for being here.
Yes. Thank you, our three speakers. And on behalf of the organizing committee, I would like to express my sincerely gratitude for spending your precious time being in this webinar. And before coming to the main part of the program, I would like to invite the speakers to introduce. Yes. And first of all, I would like to invite LLM Trần Thanh Tâm. Yeah. Well, and now we would like to invite the speakers and the audience to move to the main part of today's webinar, which is unlocking Moot Court success. Well, the webinar session consists of two main parts. The first part, we will have a chance to listen to some sharing from Mr. Xuân Phong about his CISG Pre-Moot journey. And besides, we will also listen to valuable sharing from Mrs. Cardo about how CISG Pre-Moot has helped her with the career development. And with the second webinar part, Mr. Trần Thanh Tâm will present some useful information about research and writing for Pre-Moot. Well, coming to the first webinar part, I would like to invite Mr. Xuân Phong, third runner-up of Vietnam CISG Pre-Moot 2023, to share your experience during your CISG Pre-Moot journey with our CISG candidates. Mr. Xuân Phong, can you provide concrete examples of setbacks you encounter during the CISG Pre-Moot preparation, such as the difficulties in understanding the legal concepts, or disagreements within a team, or unexpected challenges during the round?
Well, so good evening again, and thank you for the question. So I think this question suits me really well because I joined the Vietnam CISG Pre-Moot at a very early stage, specifically when I just freshman. So my legal knowledge at that time was not sufficient. Most of people will say that it's insufficient to join a moot court. So yes, of course, the answer to your question is that me and my teammates, we have encountered many difficulties as a freshman joining an international moot. And if I recall correctly, one of the main challenges is that to understand the different legal concepts in the CISG and as well as other legal issues that related to that year's problem. And one of the story that I remembered the most is that I have to look into each and every problem from the very beginning without the professional help from any ex-mooters or the teachers. So like for example, to understand the concept of private international law also took us around 2 weeks to deeply understand about that concept and to thoroughly understand about the uh the fundamentals of international arbitration is also really difficult. And I remember that you also mentioned a problem like disagreement with the teammates. Uh, I'm very fortunate to have a very supportive team, and we rarely get into like quarrels or unnecessary debate, and we worked together quite well. So that is not the real problem to me. However, as I just said, a freshman joining a moot, you may expect to encounter many difficult legal questions. And that is my answer to your question.
Yes, thank you very much. You should share with us some setbacks that you encounter during your CISG Pre-Moot journey. And I'm also really curious, in order to overcome these setbacks, what specific strategies did you use? Did you utilize the research methods, engage in team building exercise, or seek guidance from your mentors or the professor?
Well, that's a very good question. And I think that in order to answer it thoroughly, it will require like maybe an hour to discuss about this problem. But due to time constraints, I will just limit to the very uh, necessary part of it. So as I said, because we did not know anything about the law, the moods, everything. So there were not actually any strategies that we planned at that time. We just followed the path of searching for reading materials and to do it ourselves and to find out anything that is useful or helpful for us to solve the case. And um, at the time I don't even know about any like research methods or any team building exercises, as you have just said. But I think that the most important thing when you don't know much about a problem is to spend a lot of time to discover and to really enjoy the process of reading, of researching, and to drawing conclusions from what you have read. And that also leads me to my point is that it is important to have a good time management plan. We started not that early. The competition was already launched in October, and the Moot problem was released around that time. However, we just started around at the start of December, which is 2 months late. So we're also in a really rush manner, and we have to allocate the time really precisely. So that is my strategy to overcome the biggest problem for us at that time. Besides that, I think maybe we did not do that, but I think what is useful for the upcoming contestant is that to have more discussion with anyone that you may find that it's helpful. For example, your teachers or your friends, even your friends can help, and like the past contestant of the competition also can be a really good source of information.
Yes, thank you, Mr. Sun Fang. Thank you so much for your valuable sharings. And I also know that you have participated in the FDI Moot, a really challenging competition. Therefore, I would like to ask you some questions about the impact of CISG Pre-Moot on your FDI Moot journey. Well, how did the research, writing, and the presentation skill during the CISG Pre-Moot translate to your success in the FDI Moot? Were there any particular skills or approaches that proved especially valuable?
So to further discuss about my mood journey after CSG Pre-Moot 2023, so it was a really long journey, and I have grew exponentially through the time. And to talk about that, any particular skills or approaches that changed my mind or changed my perception when it comes to a mood problem is that um I planned my time better. I discussed more and I practiced more. To specify my point, first of all, is to the skills, right? I think one of the most important thing that I learned from the CISG is that the IRAC model. I think that in the following session, Mr. Thum or Miss Carla will also emphasize on these skills is how to write a legal memo that is concise, that is logical, and that is easy to follow. Even though that I have not yet been awarded for any best memorandum for claimant or respondent, I'm still working on that. But I think to really understand the IRAC and to set out each step during the IRAC process can help you a lot with your memo writing and memo preparation. And about the oral round, I think that uh, my approach has changed a lot. So before, when I first joined the Pre-Moot 2023, I did not do the practice with my teammates regularly. We only have like two rehearsals at that time, which is a really small number in comparison to other candidates. And after that, I realized that practice makes perfect. I think we can all agree on this point is that the more you practice, the more you get yourself familiar with the mood problem and the more confident you become with the mood problem and the more confident you become when you present yourself in front of the judge or the tribunal. And I also learned more about, of course, my legal knowledge also increased throughout the year. So it was a bit easier for me to do the analysis on the FDI mood problem. However, it's still like two completely different um, legal fields. So maybe I can say that I'm still a newbie or a rookie in the FDI mood. And one more thing that I would like to share to the participant this year is that trying to find other teams that also join the competition and to have like mock hearing with them. Whether or not you have a real arbitrator that can sit on that match or it's just a friendly practice, it is important to have real competition feeling with other teams that you don't know what they have in their hands before the match. So that will help you to get yourself familiar with the courtroom setting and with the pressure that the judges might put on you later. And one more thing, uh, okay, I'm maybe a bit lengthy, but I want to add another point is that regarding the research skills, I think in order to do better research, you have to have better source of information. So don't regret I'm sorry, don't hesitate to reach out to those that have the valuable materials that can help you during the competition. And one of the main challenge, I think, for most of the Vietnamese competitor is that your access to valuable materials are quite limited. And therefore, you have a very narrow view of the moot problem. In order to have like a broader view of any moot problem or any legal issue, it is important to have different perspective that people share on the problem. So again, reach out to ex-mooter that might have the material, the books, the commentaries, or anything that you find necessary for your research process.
Well, thank you for your very useful sharing. Um, However, Mr. Sunpom, can you please give our candidates some advice or suggestion for their current competition based on your experience in the CISG Pre-Moot and all the competitors? What are the most crucial pieces of advice you would offer to current competitors? What should they prioritize their preparation, or what common pitfalls should they strive to avoid?
Well, again, this is another tough question. Um, so from my point of view and based on what I have been through all the moods and through all the subjects or projects that I have participated in my university, I think it might be the most crucial, but it's also the most simple. As I've just said earlier, is that practice makes perfect. So since I think that we all agree on this point, so I think I will move on to the next one, is that don't be scared. I have talked to many of my successor, the younger students in my university, and one of the main challenge or like when they thought that they think of the problem of whether or not to joining a moot or not, they are usually terrified because they thought that they are not competent enough or their legal knowledge is insufficient, etc. There are many reasons why that bar them from joining a moot. However, from my experience, I think that it is important to know that don't be scared because if you view this as a competition, then of course you get scared of the results of the comments from the judges. But if you see this as a learning opportunity and the chance to have discussion and to have exchange with your fellow mates, your fellow students, or the judges, then you will have the courage to join the moot. And regarding this point, I think anyone can join the moot regardless of what year you are currently in or what university are you in. You all have the possibility and you all have the capacity, the chance to success in a moot court competition. And what should you guys should prioritize contestant, you guys should divide the time equally for the memorandum, for the writing phase, and for the oral phase, because each phase has its own meaning and each phase is important. And in some competitions, I know that they also added the point of the writing memo with the oral hearing to have like a overall score to rank the team. So prioritize time management. Second thing is that to prioritize practice, practice. Uh, no matter how much or how many matches you have joined, it is not enough for a real match at a moot court competition. So don't underestimate or don't take things for granted, especially things that are relating to a courtroom hearing, to mock hearing with other competition. And to avoid anything, I think one of the main um issues, not technically not issues, but like a mistake I realized from other contestant is that uh don't be afraid to share what you know or what you have done researching to other contestant at that time, because they also have different things that you haven't touched upon yet, or they have other things that might be helpful to you. So try to reach out to, if you know them, if you by any chance know the other contestant in the competition, reach out to them and to have open discussion to so that you can gain more. You give away your knowledge and you also gain something for yourself and for your team. And that will definitely help you guys during the competition. Well, I think that may answer the question that you just gave me.
Yeah, thank you, sir. Wow, the last question we have for you is, so the participating in the CISG Pre-Moot enhance your confidence in approaching the international law moot court competitors. So did it influence your approach to research, argumentation, and your courtroom performance in the FBI moot?
Well, so I must say that um, it definitely did influence my approach to my university journey as a whole. It's because it's the very first thing that I did during my university years, and that's why it built the foundation for everything that I did afterwards. So it shaped my approach to a legal issue. It shaped my time management skills. It shaped everything. Like, for example, the way we divided the work between the team members, that two of you will do the procedural part, for example, and the two other teams will do the merit part, for example. And that model follows me through every after the other moot competition that I joined after CISG Pre-Moot. And one more thing, I'm not sure if it's funny or not, but there's a book. I bet you guys may know it or heard of its name before, which is Redfern and Hunter on international arbitration. So when I first joined the CISG Pre-Moot 2023, I haven't heard of this book yet. But after I was introduced through this kind of webinar, that year I also joined the very first webinar of the Vietnam Pre-Moot 2023, and I was introduced to this book, and this book has also followed me through every other competition. When I want to search for something or some legal concept, the very basics one, that is the book that I will look for. And CISG Pre-Moot has taught me a lot of things, and it also helped me to understand that I'm more capable of doing things than I expected. So that makes me feel less scared or less terrified when coming to try new things or to step out of my comfort zone. And yes, I think that will conclude my answer.
Yes, thank you very much, Mr. Sun Fang. That was such a useful sharing. And I believe your recent sharings can help our candidates a lot for the current competition. Well, and now I would like to ask Mrs. Carado, champion of the Vietnam CISG Pre-Moot 2020, a question. Dear Mrs. Carla, yes, and I believe that CISG Pre-Moot Championship was your first experience ever with mooting, right? And can you please share with us how this experience has impacted your career path development?
So hi, everyone. Good evening, everyone. Thank you for the question. Every time I'm asked about CIG Pre-Moot, I get very shy talking about this experience because it feels like I get to brag again about winning championship in my first time competing. Like Mr. Fong, I was also just a freshman who had been in law school for what, 3 months, right? So really, what did I know? But I think a lot of it I have to credit my teammates because they're just the most excellent teammates, most wonderful friends. They are just incredible oralists and they because they came from a debate background, whereas I had a more of a model UN background. So like we didn't know anything. We all of us were first timers. We didn't have any experience. And we were just bringing what we had to the table. And we started from scratch. We did our research from scratch, like Mr. Fong did. We also look up all the books, the resources, like books like Redford and Hunter, the commentary of the CISG as well. And yeah, we did all of that. We went to workshops, we sat at seminars and webinars like this to find out the tips and tricks to build up what we can to prep for the competition. And so I think because we were in that situation where we did everything kind of on our own, figuring things out on our own, we were able to put a lot of more effort, as in like being more proactive and taking initiatives, um, which I will talk about later. But just on the point of having really good teammates, I think if you have a team that has a strong mindset about this competition, I think during the time in the competition, you can easily get discouraged, especially the time when you're figuring out the mood problem, reading it, and then writing the memorial. It's easy to want to give up. Like it's really easy to have that feeling. So it's important to have good teammates who will encourage you, talk you through the problems. Like maybe we don't quarrel, but we will have debates among ourselves about this issue, that legal issue within the problem, and lift each other up, if that makes sense. Because I think rather than having the best or the most excellent teammates, or the teammates with the most experience, even with first timers, you can achieve something along the way because if you are able to find people who share the same goal as you, it makes the whole process really easy. But since Mr. Fong has already talked about research and teamwork skills, I don't want to press on that point, but I want to talk about the things that really impact my I guess career development path, but also my journey in university is the skills that I've gained, the biggest skills that I've gained are like advocacy skills, my legal analysis, and the networking opportunities I've gained from the competition. When I was doing when we were prepping for CISG Pre-Moot, I think we were able to have a lot of rounds. So we had like schedules to practice among ourselves, and we were doing it like weekly, almost sometimes really intense, like 2 times a week. But like Mr. Fong had said, it's also good to have some matches where you're not just doing it among your own team, but also with other team. I kind of disagree on doing that too much because I've been through the process of doing that too much with other teams and when I was in the competition myself. I met that exact team. And so it's just personal anecdote for me, but yeah, I agree that it's good to have practice with other teams. Um, not too frequently, but exchanging of ideas is really important. And advocacy skills is something that you can improve over time. The more you practice, the more you get better. The more you get that confidence to do it. And it's important to reach out, like I said about proactiveness. It's good to reach out to people, to ex-mooters or even your teachers, to anyone you know, really, to so they can be your guest arbitrators, or they can talk you through a problem, or you just approach them with the points that you want to make, and maybe they can give you some questions, which will then help you not only build your script, but also to build that like bank of questions you can prep ahead. Not saying that it's that you will follow that when you're in the competition, but it's good to have everything prepared. But like I said, doing Moot is all about being persuasive. Since I've been chief secretary of FDI Moot before, I'm very honored to have the opportunity to sit in those deliberation hearings where the arbitrators talk about why this team did a little bit better than the other team, and then usually it almost always comes down to the persuasiveness in your advocacy skills, whether a team was very persuasive or not. If you are very, I guess, stubborn with your ideas, or you're really much trying to rush through a question, it's not that as good as you trying to get to the point and stick the landing for the question that the arbitrator is asking you. So I think that having able to go through those competitions really helped me understand what people are looking for, and my listening skills, and being able to precisely answer and pinpoint what an arbitrator or a teacher is asking you. I think that's also really good skills. And I think the last skill I wanted to talk about was networking opportunities, because students who I met during the competition, who some of them, one of them has gone on to become a dear friend of mine during my study at ANU. Um, or the arbitrators who sat in my hearings. They became mentor in my guest scholarship program, or I've also met people who led me to the opportunity of working in FDI Moot competition as chief secretary as well. And I think I wanted to make that point about how CISG Moot is really good, and I think it's because there's not, I think CISG Pre-Moot is one of the rare competition in Vietnam that allows you to sign up. Like it was not as popular before, but it sometimes is really hard for other competition, because sometimes other competitions force you to be like representative for the school. So some school would have like in internal competitions in order to find the team that represented the school, whereas CISG Pre-Moot was the first moot I attended, because we didn't have to go through that lengthy process of asking teachers or for permission or whatever, but just signing up as ourselves. And especially now that CISG Pre-Moot allow foreign teams, you have really good opportunities to meet foreign students and compete with them on an international level, which means that you'll be able to face really good competition and learn a lot from your fellow competitors as well. And I think just one last note on this is that I think being in doing moot competitions reminded me that I have to build my professional profiles really early on in my career, which is like, having a LinkedIn account prior to the competition, so that you can connect with arbitrators who sat in your hearing or your match. And then right after the after that match or that day, you can connect with them, ask for feedback or guidance to improve. I think those are some skills that I would say. Yeah.
Yes, thank you so much, Mrs. Carla. Uh, and I know you're completing your master degree at the moment. So do you think that your experience with mooting has given you a comparative advantage over the fellow law student peers?
Oh my God. Yes, thank you for the question. I cannot stress enough about how mooting has helped my experience during my time taking the courses at ANU because you'd imagine that, okay, I took international arbitration class where we had a group exercise that was like worth like what, 20%? That was like literally the title of that exercise was to find out whether an arbitration clause was defective or workable. And it was due within like 2 days or something. And the funny thing is I actually pulled out my research notes from CISG Pre-Moot from my first year to find out to research again about unilateral clause, and it's the exact same thing that I was looking for. So I'm telling you, these all these information that you're learning from FDI, CIG pre-moot or whatever moot that you're doing, it is really helpful because especially if you're doing an issue of jurisdiction or you're trying to prove an arbitration agreement is valid or invalid, and it will become a massive help in future in your courses if the exercise is to find out if that agreement is valid or invalid. And I think I find it funny that a lot of people say that studying in school doesn't help. But I think that's not true at all. Basically, if you're in legal, you know that everything in your studying in school is the foundation for most problems you're going to encounter, be it at work or the competitions that you're prepping for. And another example I want to give is that during my international commercial law class, for example, our final paper was a case note for a court decision that was like 100-page long. And you know what? I did that all in 30 days with the help of skimming, reading, identifying legal issue skills that I've gained from CIG Premoot. Because when you're accustomed to reading a lengthy moot problem like this moot, for example, you'll be able to easily find the key legal issues, how to analyze a decision well, especially using IRAC. And when you have when you kind of you already know where to look for the legal issues or the line of reasoning for those legal issues, it makes everything more easier, your writing process is much more efficient. And so like I said, I just want to press and emphasize the fact that doing mooting is a massive help for you, whether it's for your uni life, your future uni life, or your time at work. And especially if you have plans on doing a master degree course in foreign country, because perhaps the exercise will be exactly the things that you encounter during your mooting competition. And it's just tremendous help that you will definitely have many chances to pull up the skill sets that you acquired from your time mooting. So yeah. And I think one final note is that I remember it's so funny because one of the textbook for our courses was Redford and Hunter, and that online copy at our school is only available online, but it wasn't accessible to everyone. And since I had a copy of it in PDF version, I was able to share it with my group mates who I was working with. So I think, so like I said, I'm just trying to irritate the fact that doing all of this really helps you, whether it's doing master degree or if you're working, it's gonna help you in your future. And so really just do it.
Yes, thank you very much for your sharing. I believe that our candidates have learned a lot from what you just shared about the experience and the process while you of the preparation. And thank you. And dear our precious delegates and audience, the final section of today's webinars promised to be particularly special, and I believe it will be extremely beneficial for all candidates here to gain knowledge from Mr. Trần Thanh Tâm. And now I would like to invite Mr. Thâm to guide CISG candidates on legal research and legal writing, how to structure and to prepare for the memorandum in the Moot.
Okay, thank you, Lynn, for the introduction. So before we start, just shout out to the two wonderful guest speakers today, Sung Phong and Kalado. And you may see that the two, they are joining the CIG Moot very early stage, if I'm not mistaken, in very first year student, and they are going very far, very, very far. And it's remind me of the quotation that I really like. Is it impossible until it's done? Yeah, so just jump into the competition and let's see how the competition will treat you. So definitely you got a lot of fun like Kalado and also Sung Phong mentioned. And who knows, you may be the winner in the next competition, right? Okay. So just bear with me. I gonna share my slide here. Okay. Yeah. So yes, my name Tam. You may see the title here. I'm the senior lecturer at the Department of Economics and Law. I'm based in Ho Chi Minh City, Phong Trạch University. And also I'm working at the senior legal advisor at the Lam Law LLC. That would be the company located based in Ho Chi Minh City as well. And at the same time, I'm an arbitrator at the Southern Trade Arbitration Centre. So what I'm sharing with you today would be focusing on very tips of the iceberg here, but actually legal research and writing in the CIG Pre-Moot. So we got a lot of upcoming series that would train you in that journey. So my today focus would get you to get to know and get an overview of the legal research and writing in the CIG Pre-Moot. Before we start, so it's just a acknowledgement that my training today that would be sharing from a lot of work from my college. You may see here that would be the recently series Africa in the Mood workshop. So if you got more time, then please go online and have a look on the advanced famous legal writing and also other seminar there. It would be valuable for you to follow all that information. Okay, so let's start with the part one today, legal research in the CISG Pre-Moot. I think let join me in a very easy question, and I want you to I really think that you may have some idea in your mind, but I'm curious, what do you think about the answer for this question? What type of authority recommend you to address the Moot problem or maybe the CIG Pre-Moot problem? So I think Phong and Kalado also mentioned some kind of authority, but it would be nice if you can share with everyone here. Any authorities that can be used for your upcoming mood problem. What could be the sources that you can base on here? Okay, so let me share with you the let's just start with the screen share. So So again, I think you also see the question here, right? Yeah, just feel free to come up with anything that you might think is a could be the authority, could be the sources, right? So, so far we got treaties, we got case law. Come on, everyone, we can do it better. We can fill in all the information here. To respond it, you still can have multiple responses, okay? If you still think about other authorities, so feel free to write down your answer here, okay? Scholarly opinion, yes, scholar opinion, that's very good answer. Okay, what else? Scholar opinion, treatise, case law. Is that only three sources of law or sources of authority here? Convention, yeah, convention, yeah, really on point. Okay, what else? What else? Come on, everyone. President, scholar opinion, sub law, okay, very good. Commentary, yes, commentary, yeah. What else do we have here? Contract, yes, contract, yeah, definitely, contract, yeah. International custom, yeah. Model law, statute, yeah. It's getting a lot here, yeah. Okay, that's good, that's good. National law, okay. National laws, um, commentary, model law, statute, constitution, yeah, constitution. President, international custom, sub law, commentary, rules of procedure. Yeah, rule of procedure. Yeah, law review. Yeah. Okay. Okay. So most of the answer I am anticipating you to answer is already here. Okay. So thank you for sharing, everyone. Thank you for sharing. And this question just a reminder, and it could be you could be well aware of all the information that we can make use of when we do research for the moot problem. Okay. So yes, thank you for sharing information here. I may cap the picture from this and share with you after the end of the session here. Okay. Okay. So let me straight to the point. Normally, when we got the problem, when we got the problem, so I think it can be easily to go straight to the legal test here. The legal test here. So some of you already mentioned the legal test here. You mentioned, for example, the convention, you mentioned the national law, you mentioned some other international treaty, for example. In the context of the VISM, probably the legal text, the first one that we have to mention here, that must be the CISG. Okay? But in a CIG, it may have some other law would be under law as well. So, for example, it could be other national law or domestic law, for example. Okay. Um, we find the specific provision in each legal text that apply to your problem. So CIG, they got around one article. So which article, which provision would be relevant to your issue? Is that Article 7, Article 25, Article 49, or a number of article here? Okay, but law, it could be a good start, but it's not just start there, right? So look for secondary sources. So what are the secondary sources here? What are the secondary sources here? So secondary sources here, that's really diverse. And most of the time, people refer to academic or scholarly journal article. Okay, it could be journal article, it could be book, it could be monograph, it could be commentary, and those are the scholarly opinion, as your friend mentioned. Okay. And most of the time you can see that it would be in the form of the journal article, or it could be book. Okay. And I think that's it, the two most popular form of the secondary sources here. Okay. But also be aware of the relationship of all other provision of the legal text in which the specific provision is found. I want you to have a bird eye view here. Okay. Don't just look at your issue. Your issue here may be Article 25, but article in here that is in connection with other provision of the CISG as well. So when you think about the Article 25, you also need to see, okay, how is it connected to other article in the same legal text as well. So that's the thing that you need to keep in mind. Um, yeah, so it can be also secondary sources, but you may see here that when the CISG is established or drafted, so they also got the drafting committee there. And they also is available for you to see the drafting history of the legal text being considered. At the end of the day, CIG, that would be the products of compromise of so many different countries. So you see that they got so many options why one article wrapped it. For example, whether it's follow common law, whether that follow civil law, or what would be a combination of the two. So you need to look at the drafting history to get to know the idea, the origin of that article, and that may give you a comprehensive meaning of that article. Okay, and it's very important to find the interpretation of that provision or that article. You can do so by two main ways. Number one, you can look for the case law. That's one of the sources of law that you mentioned in the Mentimeter. Yeah, case law normally that could be the judgment made by the court or the award made by the arbitral tribunal here, or it can also be available via a lot of scholarly opinion made by the commentators. So those would be the two main source of interpretation here. So keep in mind that CIG, we don't have a authority who have the power to interpret the CIG here. So the interpretation here, it can be number one from the court and arbitral tribunal, or maybe from the commentator here. Okay. And also, as a general rule, when you read a document and you need to go through all the footnote or the sources that they mention in that document, and from that they bring you to another level. Okay. um how can you are good at that? You just keep reading and keep searching and keep getting lost in the jungle of books and references. Okay, that's how we do it. Research fact, law, and policy is also important to set your argument to support your outcome. Now, so this first slide gives you an overview of all the authority or the authority that you can use for your research to address the legal problem in the mood. Okay. Now, to give you uh, a specific examination, maybe a specific illustration here. So I may give you some more information. Get through the example here. This is the problem of this year Vismut. Okay, so you can probably see that problem on the website. Okay, I just try to wrap it up a little bit here. The problem this year happened between two companies. One that would be the Green Hydro PLC, and we got Equatorial Rain Power Ltd. The claimant here that would be the private company and specialize in planning, construction, and startup plans for the production of green hydrogen. And while the respondent here, that would be the state-owned company, the state-owned company. Okay. Um, just keep an eye that my phone is out of battery very soon, so let me know if you cannot hear me well. Okay. So responding here from the state-owned company. So it's very interesting, right? That is the this state-owned company and a private-owned company, whether it's a governed by the CISG, whether the CISG can be included in the case, and how is it applicable here. The dispute arises from a contract between two companies for the construction of the green hydrogen production plant. And also, you see that the project was part of the green energy strategy and aimed at achieving net zero by 2040. And you see that following the public procurement process conducted through a reverse auction, so green hydro proposal was selected and the contract actually signed in July 2023. Political changes in Equatorial led to a shift in energy policy, including a re-evaluation of green hydrogen projects. And for that reason, responding, they terminated the contract in February 2024, citing the claiming delay in delivering final plans and asserting a legal right to terminate, which Hydro contested. Okay, and this agreement already escalated into the current arbitration. So that is just the background of the problem. And you may see that is the process, the timeline of the dispute between the two companies. Okay, now you don't need to go through all of that. I'm just get directly to the problem. One of the problem they may ask you here, for example, here, if you look at this slide, the arbitral tribunal hereby met the following order, and they put number one in the next submission, the party are required to address the following issue, A, B, C, and D, for example. So even if you are the claimant, if you are responding, when you submit your memo, you have to answer, you have to address all the issue that mentioned here, okay? And just get into an example here. So I give you the point D. So let's say if the CIG already applied and we address the last bullet point here, whether the party validly excluded the application of the CIG or not. Okay, now when we think about that, we think about the process that I asked you at the very beginning. Okay, now can you guess if we base on the legal test of the CIG here, the legal test of the CIG, so which article would be relevant here? Which article of the CIG that handle the exclusion of the CIG? Which one would be relevant here, anyone? we got 101 article, right? 101 article, but the only one specific article handling the exclusion of the CISG. And I would say that is Article 6, everyone. Article 6. Okay. So let's say you are the beginner. You don't really know about the CISG. And okay, you know that, okay, this is Article 6, but seems like the Article 6, what is the problem with Article 6 here? The Article 6 here, they may just mention like, okay, the party may exclude the application of this convention or subject to Article 12, derogate from or vary the effect of any of its provision. It's just two lines only and very general. Okay, of course we cannot just based on the legal text here to handle the problem. Okay, so let's go back to what I said to you. Now, we already defined the specific provision. Now we need to think the relationship of Article 6 here with other article in the CIG to get an bird eye view here. Okay, and think about the secondary sources that would be relevant here. Think about the gene history. Think about the interpretation of the Article 6. Think about any other secondary sources, journal article, books that would be supporting you. You hear me, everyone?
Yes, I can hear you clearly.
Oh, okay, you hear me, but I can't hear you. Okay, anyway, it doesn't matter. Okay. Now, yeah, so okay, let's continue then. Let's continue. Okay. So, Article 6, the party may exclude the application of the convention. So that would be the good start today, right? And the relationship. So how can we identify the relationship here? How can we identify the relationship here? So you also refer to some commentary of the CIG, okay? If for the international arbitration, I think Fong and Galado already mentioned about the international arbitration made by reference Hunter. So that would be everyone in arbitration, they know about that. So it's the same with the CISG. So for the CISG, I think one of the very prestigious book and the textbook that everyone should know. That would be the commentary on the UN Convention on International Search of Goods, and that would be written by Swenger and also Slattrian. So that is also a very famous CISG leading scholar in the field. Okay, so you can base on that to have some idea. And now getting that book in Vietnamese also in Jaipur. Um, but yeah, so just ask your mentor. Okay, ask your mentor if they could have for that. For example, in this one, they would say that Article 6 in conjunction with other article, for example, Article 30, 53, 55, Clause 1, or Article 32, and it may express a general principle here. That would be the principle of freedom of the contract, or we can say party autonomy. Okay, so that got you some hint about the article. Okay, now that is about the relationship. Interpretation of the CISG and particularly Article 6. Where can we find out the interpretation here? I told you already, they got two sources of interpretation. The number one, that would be from the commentator here. And for the commentator, then you may see that, and I saw you here, that would be the CISG Advisory Council. So we got the Advisory Council, and they are in charge of making so many interpretation. And the function here, the purpose here is to make the application and interpretation of the CIG can be more uniform all around the world. But be aware that this is persuasive authority only. It's not binding at all because there is no other authority that have the power to interpret the CIG here. So again, that advisory council opinion is could have the persuasive authority that could be for reference and could be for you to base on to have a uniform interpretation. Okay, so this can be widely acceptable by the leading scholar of the CISG. Okay, so when you refer to the CISG or any article here, don't forget about the interpretation of the CA Council opinion. And they got so many different opinions here. And I think that would be a good start for you to get to know the interpretation. Okay? Yeah. So number two, yes, in addition to the interpretation made by the CIG Council, then we got another um, interpretation, and that a practical way. That could be the case law. Okay, case law. And the case law here for the CISG, it can have two main sources of case law. Number one, you can access via the PACE database. Okay, PACE database. Just a PACE, then you can see all the updated cases there. And also you can go to another sources of law. We got Unilas, for example. Unilas, it's also available for case. But another challenge for you here is that not every case written in English. Especially CIG is well developed in European countries. So some of the decision made in French, some other decision in other languages. But nowadays with the support of the AI, I think you can use the AI for the translation. And I think for this Moot competition, AI translation to get to know the idea of the case law, it would be acceptable. So please make use of that tool to get to know all the case law. Okay, so as your friend mentioned, Calado mentioned that is at the end of the day, the evidence or the thing that you bring to the arbitration table is the persuasiveness. Okay, but the persuasiveness here is based on your argument bring to them. So you need to pick up the right case law. Okay, so it is your job. No one can help you with that. Okay, how can you find out the right case law? You start with the secondary sources. You need to read the commentary of the other scholar, and they may mention some case law. And you go to that case law and may have a look. And maybe it's maybe not updated yet, and you need to find other way
to find out the new case law and any other case law that share the similarity with your case. Okay, so that make your group stand out the ground. Okay, so find out the right case law which is relevant to your problem. Yeah, and here some of the provision in the CISG that also connected with some principle in the law as well. So your job here to get to know that principle, not just read the legal text only, but also refer to secondary sources. Lisa Spagnolo, also another key author in the CISG field. Okay, so I will send all the information via the slide here, and you may have a look on some of the book I'm recommend here. And I think that those are prestigious textbook in the field of the CIG that you can follow. Okay, so that is the very first part, and I hope that it can give you an overview what you really look for when it's come to research for your problem. Okay, I know that in some cases it's really hard to find out the right article, given that you don't have the permit to subscribe or you don't have money to buy that journal article, but your mentor, your lecturer still can do so. Okay, and networking, like Carla Dorsey study in INU. She got the account to accept a variety of books and journal article there. So just ask your friends, ask your colleague, ask your anyone that can support you, and you can find the solution. Okay. The more you read, then the more information that then you can observe in, and it can support you very much in your making your argument. Okay. If you read 10 article, it's totally different when you read 20 or 30 article. Your argument is what you read. So that is my recommendation for the first part. Okay. For the second part, because we still got another training series that will focus on about how to write a memo. But basically, what I provide to you very basic information, and it can help you got an overview. Okay. So general of the memo that we got the cover page, we got table of content, we got abbreviation, we got index of authority. The term index of authority I already explained in the very beginning. So you can mention the article, the other legal sources about the scholarly work, information that you base on for your work. Okay, index of cases, statement of facts, a summary of argument, and also last but not least, that would be the conclusion. Okay. The structure of your memo, normally each issue, they got several issues, and each issue should have an argument heading. You got an argument heading, and this will be followed by argument subheading and other subheadings. Okay, an argument heading should state the conclusion of the argument to follow. For example, you can see that part one, it could be procedural issue of arbitration. Then we got heading one, heading two. For heading two, we may have subheading one, subheading two, subheading three. So basically, that is the structure when you make your argument, and that would go belong to your table of content. Okay. Example, I think for this mood, it's very convenient. You got all information that you have. Just go directly to the website of the Vietnam, and you may see, for example, so here, the best claimant memorandum, the best respondent memorandum, and who knows, maybe next year could be your name would be listed there, right? Okay. So you just go click there, a memorandum here, and you see this is an example of how they make a table of content, and also the way that they show their argument here. For example, if you may have a look here, respondent cannot rely on Article 80 CIG to refuse payment. That is the argument. And that may be the conclusion that they want to make there. Okay. And then they got subheading. And also this is a sub-argument here. The party did not agree on a duty to inform about cyber security incident, or under the law chosen by the party, claimant had no duty to inform about the cyber attack. So you see that all this is about the argument. Okay, it's all about the argument. So you might have a look about the website and look at all the memo from the plaintiff, from the defendant. They give you an overview of what you are about to do. Okay, so when you got the sample, then you just follow the sample. That's a good way to do. Okay. I think Phong mentioned a very good point that when we do the argument, one of the methods for every law student that we need to do that would be based on IRAC method. Okay. For those who don't know IRAC method, that stands for issue, rule, application, and conclusion. Issue, you would say, okay, what is the problem here? What is the issue here? State the conflict. Rule, you need to state the principle governing the conflict. And the rule here can be from law, it can be from case law, it can be from other authorities. And we mentioned the authority at the beginning. It can be secondary resources, it could be interpretation, or any other resources that can support your argument here. Okay, and application based on those rules, based on those authority. So how can we apply that in this problem? Okay, so apply the rule to the facts and state the outcome, and then you may come up with the conclusion. Okay, so if you got the IRAC in your mind, then it can help you like a very logical way to organize your argument. Okay, a lot of information about the IRAC method here, and I'm not intended to give you an overview or a detailed information about the IRAC. But yeah, when we build up an argument IRAC method, that would be a good guideline for you to follow. Paragraphs should follow naturally into one another, and one idea should lead logically to the next one. And paragraphs should be at least 2 or 3 sentences long, at least, okay, and have 3 distinct parts. For example, we got a topic sentence, and then we got supporting sentences, and we got concluding sentence. Okay. When you make an argument, just one more thing I want you to pay attention to. It's not just about make an argument like, okay, this is my statement, and then you got the reason for that, and you got the evidence for that. But it's not just stop there. What is missing here is, what is the counter argument? And how can you battle that counter argument? Okay, so that makes your argument strong. Okay, so every statement when you make, think about, okay, next question, what is my reason? Why I support that one? Okay, number 2, what's the evidence? Number 3, what is the acknowledgement? Who also support that? What are the authority also support that? Okay, then last but not least, what is counter argument? And how can you handle that counter argument? Okay, so when you answer all that one, you already persuade yourself. You know that the memo is not just for the arbitrator. General reader, then they read it, they understand, then that means you already success on that. You can be successful on that. So try to make an argument that everyone, every non-specialized audience, they can still understand what you want to express. And it's really support you not just in the writing and also for the oral hearing as well. I got some example, but maybe you may have to look at that later on. Yeah, so persuasive writing, advocate for your client. And the point I already mentioned that you should include opposing argument and response. Okay, what is the counter argument and how can you respond to that? Okay. Sample memos already on the website. Just go there, download it, and take time to read it. Requirement of the memo for the VISMUT, I think is already on the website. Every information that you can follow. Okay. Wrap early and wrap often. That is the second point I want to mention. Phong said that he jumped into the competition very late, 2 months late, and he don't have much time for rehearsal. And I think it's the same thing with the rap as well. So rapping is also important. It's important as well. We got rap, then we do rehearsal. Okay, so you need to you need to got at least 2 rap for revision prior to the final draft for submission. Okay, the more the team rewrites, the better. It's good in when you do like thesis and when you are your final year of your master degree or your bachelor degree, you have to complete your thesis. Believe me, first draft never good enough. Sometimes you could say, okay, how can I send a rubbish to my supervisor? But that's the way that we improve ourselves. We learn during the process. We learn from our mistake. I think that's more important. Okay, no one perfect from the very beginning. So just try to deliver the rap as soon as you can. And they said that it's never good enough for the first time, and it's also not good enough for the second time. So you just keep practicing, practicing, and practicing. Okay, practicing makes perfect. It's not just for oral hearing, but also for writing as well. Um, do not be afraid to demand a rewrite if it's not good enough. Okay. And many teams schedule. You can see here that the technical element of the most time consuming and challenging. Okay, how can I do list of authority? Oh, how about abbreviation and lots of things here, table of content, about citation, make sure that it's uniform, and paragraph numbers. Okay, so the advice here that give your team 2 or 3 days before the submission to finalize all the technical elements. Okay, for me, a good memo is start with the good form and format. Okay, so it's so that okay, your group are diligent enough to treat the paper or memo in a very professional way. Citation for the VISMUT, they don't have any particular citation. It's up to you, but you need to be consistent. You need to be consistent. Okay, and I think Vietnamese students they got the problem here. Sometimes they read information, they follow information from the source, but they don't sign. Okay. And I see that a lot when it's come to assignment in the university. Um, I think for the memo is a requirement that for every argument that you make, you need to show the authority here. So my advice here that sign whenever you write. And it's a oversight then to undersign. So every time that you mention a fact, where you get that from? Is that the contract? Is that the PO? Is that the meeting note? Sign that in. Whenever you mention a rule, which article you mention, when you mention about the opinion from authority, then tell everyone that where should you base on. Okay, that shows that your argument is convincing. Okay, so If you see an argument with that supporting citation, it probably means your team have not done enough research. Okay? And after the drafting, then we do the reviewing. Okay? Reviewing is also important. It's not just a review between your team, it could be your mentor, it could be your supporter here. Okay? And the checklist. Checklist here also important. Check whether we already cover all that thing and spell check. With the support of the AI, I think the work can be more easier here. But yeah, those things should be aware. And final tip for the memo. Number one, review a winning memo from the VIS website. That's it, I already emphasized. And should I read the problem first, or should I write first, or should I do in pitching? It's really depend on your team. Read the problem in pitching. Read the problem as often as you can while your team researches and write the memo. Okay. Anyway, that's a working document. So keep reading. Every time you read, then you may come up with another perspectives. Okay. And review the CIG and maybe the procedural rule from the arbitration center so you can spot the witnesses in your argument more easily. Okay. So I hope that the two main part here give you some overview of legal writing and also the legal research for the Vitmus, and hopefully you can get some of it for your upcoming moot competition. Thank you, everyone.
Yes, thank you for your very useful sharing. Well, I think that not only me, but also all the candidates have already grasped the fundamental approaches to commence with moot problems. Yes, and we sincerely appreciate the valuable sharing by all of your speakers today. And I think that right now, all candidates have acquired additional skill serving their process of crafting an outline. Well, and after more than half of the program duration, the contestant team have gained a deeper understanding of the purpose of today's webinar, and the organizer found a significant number of questions arising from our participants. And therefore, I would like to move to the next part of our webinar, which is the Q&A section with our esteemed speakers. Well, in this segment, our speaker will directly address any questions related to the program. So if you have any questions, feel free to raise your hand, then the organizing team can grant permissions, and you can ask questions and interact directly with the speakers. Alternatively, you can leave questions in the box chat, and I will read the question for our speakers. Yeah, as I can see, like three. Well, Colin has seen your hand. Please, Phùng Phương Anh, can you open your micro and state your question now? Please, Miss Phùng Phương Anh, I can see your hand. Please state your question. Okay, please, Vũ Lê Thảo Anh, can you open your micro and state your question?
I think that the raise hand at the very beginning, from very beginning till now. So I probably don't think that they have the question. But Nguyễn Phương Linh maybe have the question then.
Oh, yes. Yes. So can I please, Nguyễn Phương Linh, open your mic and speak the question?
Linh, I think you are on mute.
Can you hear me?
Yes.
Uh, dear Meter Phóng, I have a question. I want to ask you that how can constructing a timeline and using diagrams or mind maps can enhance the process of identifying legal issues in a moot problem?
Okay, so first of all, thank you for your question. And I would like to ask the MC is that we will collecting all the questions, then we will answer it later, or we will answer it directly.
I think that you can directly answer the question. Thank you.
Okay, so thank you for your question, Ms. Phương Linh. And my answer to your question is that uh, building a timeline, as you said, or a chronology, to be specific, it's like one of the first step when you encounter the mood problem. Well, of course, after you read it through, but then you have to make what is the so-called that all the mooders will know is the chronology, in which it will state at what time, what did the claimant or the respondent have, what did they do at a specific amount of time. It serves two purposes. The first one is that you can remember all of the important facts of the case, and you can summarize it from like a 90 or 60 page long documents into a short and easy to look, easy to follow table that you can use later on. And the second purpose is that, as you also said, it will help you to identify the legal issues within a mood problem. For example, delay in delivery, or the non-compliance of goods, or the breach of obligation to receive goods under the CSG, etc. And my tips on constructing a chronology for a mood problem is that you should boil it down to the most important events. Try not to include everything that you think it's important. It's not important. After you're reading the mood problem several times, you will find out there's only several key events that the mood problem will revolve around. So try to narrow down each and every time after you do a chronology until you can make like an A4 page long of table. I think that is enough, and it can be fitted into one page of your table of summary, a summary of facts in your memo. And yep, that is how I usually do it. Hopefully my answer helps clarify your question.
Can I just add one more point to Mr. Fong's answer? I think that having a chronology, I think rather than using it, not just seeing it as a table of summary of the case, you can also see it as a narrative. Think of your moot problem like a story, and what you're trying to do is summarize what has happened, and having that chronology, having that key events it will help you when you're drafting the preparing the script for your oral, for example. And having those thinking of it like a narrative will help you identify the specific key events that will definitely be one of the things that the arbitrators tend to ask about the most, especially like during the first few rounds of the matches. I see that arbitrators have a tendency, if it's like the first few rounds of the competition, they have a tendency not to read thoroughly through the problem, and so they will ask again the very key points in the very factual questions. So I think having that chronology or that table of summary for the case will really help you, especially for the first few matches that you encounter with the arbitrators.
And also, I think that like you work in the team, so everyone may have their own way of mind mapping, and you need to argue with other why this is the key issue, why this is the key event, why the other is not the key event. So having a talk, having a discussion with your team, then I think it can easily make the problem can be clearer. Um, and the mind mapping here, I think is really important because number one, you may not miss out the key information, but also relevant issue that could be considered at the argument, or that fact can be the argument in your problem. So keep an eye on that and really find the way to work it and have a discussion with the team. And I think that could be the backbone. When you know the problem clearly, then you may handle that well. Okay, that's my sharing together with Caroline and Phong. Thank you.
Yes, thank you very much for our speakers' sharings. And for the next question, MC has seen your Phùng Phương Anh raise hand and can
Okay, can you hear me?
I can hear you.
Okay. Thanks for your helpful sharing. Dear Miss Carla, I have a question for you. You have just listed some necessary skills for a lawyer. So which skill do you think is the most important, and which skill do you think is important? That's my question. Thank you so much.
I think all the skills that I shared during my talks was are very important skills to my heart. But I think just within the framework of the competition, I want to emphasize the most on the listening skill and I guess mannerism, because I can share this within my scope of work is that I see that sometimes as the chief secretary of the mooting competition, I sit in those hearings as an observer. I sit through a lot of hearings, and I see that for a lot of arbitrators, they really they will really listen to your whatever you are saying, and they will really catch on your strategy, your speak like your mooting strategy, the way you structure your arguments. They will know what you're trying to tell them. If you are not listening to them, if you're like sometimes um, competition participants of this competition has a tendency to be stay too much on script, and so the arbitrators know, and that's why that can be a minus point for them, because if you're not listening to the arbitrators, it's like you're trying to monologue it. You're trying to monologue your way through a competition, and that's not the aim of this. That you're trying to persuade arbitrators, so it's very important to focus on your listening skills and listening carefully to not only the arbitrator's questions, but also to your competitors, what they are arguing. Like if especially if you are coming after, if you are claimant for or if you are claimant, for example, and you listen to a respondent talk before, and they're bringing up some points. You don't respond to, the arbitrators will immediately ask questions like, why are you bringing up these arguments when the respondent isn't even bringing up that argument? So I think listening skills is really important, as well as, like I've said, like other skills like networking skills, advocacy skills, all of that. But yeah, I want to emphasize on the listening skill and just being very careful when you are in a room, especially since online mooting is more popular nowadays. I'm sure CISG Pre-Moot also has certain online rounds, and so they will nitpick at least some arbitrators I've seen are very nitpicky. They are very hyper focused on whether you're reading the screen, reading through a script. They will care if you are fidgeting or if you're doing something on your phone, or if simple things as if you're not listening to your competitor, if you are doing your own thing, flipping through your phone when your competitor is doing their oral. Like they can also see it as a very rude gesture, for example. So I think I want to emphasize on those two key points, those two kind of skills that some participants, like newbies may or rookies, may make mistakes and they may not know it yet. So yeah, I want to share those.
Thank you for your experience and sharings. And while waiting for the candidates to raise their hand and the question in the box chat, I would like to invite our speakers to answer this questions from the registration form first. The question is for Mr. Trần Thanh Tâm. Can our team move to a challenging questions to a rebuttal to answer them later?
What's the question? I didn't see the question here.
Here. I type it in the box chat. Yes.
Can you copy that in the panelist webinar chat? Because I didn't see any question here.
Yes. Please. Yeah. Can you see the text that I
Okay, yeah, okay. You probably read it out loud. Okay. Can our team move the challenging question to rebuttal to answer them later? Um, this is, I think, Caroline also from may share more about that. I think it's all about the strategy. It's all about the strategy. It really depends on how the hearing will take place and how they organize all the questions. For me, it really depends. Um, and let's say if Carla and Phong, they may share their other perspective because they are also participant in the Vismut last year. What do you think?
I will let Phong go first if he want to share something. I do have things to share, but I'll let
Okay,
Phong go first.
I'll go first. You can go first. The next question. Okay, so regarding this question, I'm against it. That as oralist or advocate, we should not move any questions, no matter whether it's challenging or not. Even an easy question, you should not move it to the rebuttal part or to the end of your submission. The reason why is that I've received many feedbacks from different arbitrators of different personality and different style, different jurisdiction. They all have they shared a same common point, is that when a question pops up, you as the oralist should answer it immediately and answer to your best. And they also say that they don't really expect the best answer. They just want a prompt, a timely answer, because at that time they don't get your point and they just want to clarify. They want to make things that they understand you correctly and we are on the same page. They're not trying to scare you or to block you or to derail you from what you have prepared in your script, and they are being curious. So instead of shutting down that curiosity in them by moving the question to the end of the submission or to the rebuttal part, you should try your best to address their concerns at that time and try to avoid at all costs. I may be over exaggerating, but that's the truth. Is that try to avoid to move things to the end of the submission, because by that time they have lost their interest and lost their curiosity to the questions or to your submission, and you may get your points deducted because they on different perspective that they also think that you're not well prepared and you are not yet ready to answer the question. That's why you move the question to the end of the submission. And that is my advice.
Yeah, I completely agree. Phong has basically gave you the perfect answer to this question. I just want to add that I think from the perspective of the arbitrators, because I sit in the deliberation hearings sometimes, and I see them commenting on this very often, is that they don't like seeing the teams move the questions to sub-rebuttal because, like Phong said, by that time they already forgot the questions and they don't really want to listen to you. The point there is just to help to one, of course, to clarify your point, but also at the same time to see how truthful you can be to your presentation. If you don't know, then you don't know. You just answer within the scope that you know. It's not it's not it's better to admit that you don't know than to move something to say to move you'll move the question to sub-rebuttal and then not answering it at all, for example. That's what I've heard from the arbitrators.
Okay. So that is two practical answer from the two participants here. And as I said earlier, that is depend on your strategy, because you may have a compelling reason to do so, but otherwise they may think that you are maybe under prepared, or maybe you're scared of that, or maybe you have may not enough knowledge or cover that issue. So that would be triple. Otherwise, if you have a compelling reason and that you want to organize your argument maybe at the end or in that way, then it should be okay. But in other cases, like Form and Carla mentioned, at a very common sense, it should be no. Yeah, thank you.
Thank you for our three speakers' sharings, and I think it's really useful. Well, I think the webinar is, well, if you still have any questions, please contact the organizing team or the official fan page, the Vietnam CISG Pre-Moot. We will try to answer all your questions as soon as possible. And I would like to thank to all the speakers for the enthusiastic and useful sharing. Well, the webinar in the webinar series of Vietnam CISG Pre-Moot 2025 is becoming to an end. And once again, on behalf of the organizing committee, I would like to thank to all the speakers presenting today. A great appreciation to the audience that took your precious time to participate in this webinar session. Well, hopefully the sharing of the speakers will help the teams in the preliminary round, and remember, the outline must be submitted by January 26, 2025. And before leaving the webinar, the organizing committee would like to invite the audience in the meeting to open the cameras with MC and the speakers so that the organizing committee can record your images. Yes, please, can I invite the audience in the meeting to open the camera with MC, and so that the organizing committee can record our images.
I think that the audience cannot turn on their microphone and their camera. So yeah.
Oh yes, please. Let me check it with the organizing team. Well,
Good, Linh.
yes. I have to check to the organizer that the audience can turn on the camera. Please, all the audience, can you turn on the camera? As I can see.
Yeah, I think that's fine. It's
Yeah.
probably like getting late for now. Everyone not ready to turn on their camera. Yeah, so just get the beautiful four guest speaker and also Đức An here at the picture.
Maybe the audience even like they can set the background. Yeah, so just wait for a minute.
Oh, the meeting would not allow them to open up their camera. So organizer, you please help them with that. You need to give them the permission to open up their camera.
Let me check with our organizing team. Yeah.
Okay. I'm probably leaving in the next 1 minute. Can you handle that?
Yes, please wait for the organizing committee to support to taking the photos, please. Well, have you captured the photo of us? Yes, I see the organizing team has taken picture of us. Or I just like we can take the photo of the speakers only. So I can count to 1, 2, 3. So yeah, we set the cameras. Okay. 1, 2, 3. Yes, thank you very much. Well, once again, I would like to thank to our speakers for their insightful sharing and our audience for your active involvement. We hope you found this webinar informative and worthwhile. And last but not least, goodbye and see you in the next webinar session of Vietnam CISG Pre-Moot 2025. Thank you.
Thank you very much. Thank you, guys, you all. Thank you, Miss Carla.
Thank you, everyone.
Thank
Very
you.
nice sharing with everyone. Have a good evening.
Good night.
You too. Have a great night, everyone. Bye.
Bye.